Why must a group of trustees who don't even know me must decide how my benefits should be distributed? Well, there's a good reason for it. Parliament passed this provision to promote social protection. And it did so by taking away some of that responsibility or powers that you have, the freedom that each one of us have to decide how our properties or our assets should be distributed when we pass on. Now, they did so because they want to promote social protection by protecting people that were dependent on you when you were alive. And what they're trying to do here is that they want to maintain that level of dependency. That if there were people who were dependent on you, that you were financially supporting them, Parliament wants to ensure that those people continue to receive that support, that financial support. And so they want to ensure that that support continues so that those dependents do not become destitute, do not become poor by stopping that financial support from reaching out to them. Hence, the law or this provision has now given the power to the trustees of the fund to distribute benefits to those dependents. Now, in order for the board to implement this policy, the provisions that I've just read out, if you read them carefully after you leave here, you will find that there is 4 duties that the board has been conferred with. There are 4 duties. And these duties are the following. The first duty that the board has is to ensure that members of the fund complete a beneficiary nomination. So every time the member joins the fund, they have to fill in a nomination. We need to know, who do you want to receive your benefits when you die? If the member is already in, then they must update an existing beneficiary nomination. That's a duty that the board has. It's a duty that you must ensure is always complied with. What this duty means is that there must always be an updated and valid beneficiary nomination. The second duty that the board has is a duty for them to investigate the dependents and nominees of the deceased. Now, there is no other way for trustees of the board to be able to comply with this legislation to pay benefits to dependents and nominees without doing an investigation. Because how else are you going to know that this beneficiary nomination that we have in our hands does not exclude any dependents unless you conduct an investigation? Unless you ask around, who were the dependents of this member? So the duty of the board is to get the nomination, but investigate to find out whether or not what is contained in that document is indeed correct, is indeed reasonable. And you can only do that by conducting an investigation. So the second duty you've got as trustees is to investigate. The third duty is that you now have a duty as a board, after you've conducted your investigation, to use your discretion to make the Act uses the word equitable distribution. Right? Equitable essentially means fair. The Act stipulates different ways in which you can pay monies. And so the responsibility on the trustees is to choose the best method, depending on the dependents before you. If there are minor benefits, what is the best way that you should pay this money? So that's the last duty that the board has. So I'm going to discuss a bit details in this because I think that's where the day-to-day implementation issues arise, is around how do you implement these duties. Most of the cases that end up in court, they come because of how misconception or misapplication of these duties. So let's talk about this duty for you to complete a nomination. As I've said, this is a duty of the board, but also the responsibility of the member. Now, Regulation 29 is very clear that the board must ensure that every member of the fund completes or updates their nomination, right? There is if you read Section 15 of the Act, Section 15D of the Act, it stipulates the duties of the trustees. And one of the duties the trustees has in there is to ensure that members of the fund are provided with appropriate information about their rights, responsibilities, and duties under the rules of their fund, and in terms of the benefits, responsibilities that members have, the risks associated with the failure for you to inform members of their responsibility. The other aspect of this duty is that you then as trustees have to put into place mechanism and control measures. How are people going to comply with this duty? Now, I'm aware that some funds have, they have put out a standardized form that everybody fills out, right? Which seeks to comply with this. And that's your responsibility to put into place. So that you don't have people write letters, but let it be in a format that is standardized, that can be easy understood. It should have maybe even a space in there where people can give their reasons, right? Can put their wishes in there. Why are they nominating people in the manner that they are? But that's the responsibilities of you trustees, those of you who are trustees. And how you comply is going to be different from fund to fund. But I think what is important just to understand, how do you comply with this requirement? The duty to investigate, probably the most difficult and the most highly litigated failures of trustees of pension funds. This duty is basically to say that boards or trustees of fund must, as soon as you get the information that the member has died, you have to then begin to investigate and find out who were the dependents of this member. Now, you will notice that the RFA makes it hard now for a nomination to be ignored. It says that two conditions must be present. Either the deceased member clearly excluded dependents. So let's give an example. The member filled in a nomination. Member is married, nominated the spouse, nominated the two children that are there, but excluded the other child who was born out of wedlock, who lives in Mhango, right? Whom he supports every month, sends school fees, sends grocery monies, right? Buys toys and sends during Christmas and all that. Excludes that, right? And then as a board, you are faced with that nomination. I mean, it means that that member has excluded a dependent. So that nomination would not be binding because it has excluded a dependent. But how are you going to know as trustees that the dependent has been excluded? The investigation will reveal that, right? Or at least it should. If you're doing a proper investigation, it should reveal that there is a dependent in Mhango. Let's look at the other condition. The other condition says that the nomination or the distribution is unreasonable. And the regulations say excluded, a dependent, and the distributions are unreasonable. So let's assume the deceased had nominated the spouse to receive 2%. The spouse is unemployed. She was a housewife. I'm using a she, but it could be a he. He was a husband. Right? so that we can have gender parity here. It could happen either way, isn't it? The children receive 5% each, right? And the remaining 88% that is left is nominated to a girlfriend of the deceased. And the girlfriend is a bank manager at Barclays. The spouse was unemployed, as I've said. The only source of income for the family was the deceased. You see the picture here. You see the purpose of Section 39 is to protect those dependents. Now that this deceased is passed on, this family is no longer going to have financial support that they were receiving. Nothing wrong with the bank manager's Barclays, but the bank manager is employed. It's unlikely that that bank manager is going to become destitute because they have a source of income. But this family does not. Now, would that nomination be reasonable in your minds? It would not. Would the board in that instance be justified to ignore that nomination? Yeah, absolutely. Let's turn the flip around. Let's say there was a girlfriend. She was a bank manager. Right? And but her employment had been terminated 12 months before the death of the member. And she was relying on the deceased. He was paying rent. He was paying for the car payment. Right? And that the spouse is the one that was employed. The children were nominated to receive a modest amount. The spouse was also nominated to receive a modest amount. But the bank manager was nominated to receive 50%. And this deceased member happened to have been wealthy. He also had a number of life insurance policies of at least 2 million each. And all that life insurance went to the spouse and the children. And there was only about 500,000 pula in the death benefit. And 50% of it was nominated to the spouse, and the remaining 50 to the girlfriend, and the remaining 50 to the child and the spouse. Would that be a reasonable nomination? Okay. The point here is that reasonable minds can differ. What I'm trying to emphasize to you is nominations are important, that they must be completed. But the decisions that trustees must make must be informed by the facts of each case. It's a major risk now for trustees in making these decisions because people are going to disagree with you. You are going to disagree with each other, which is fine. It's safe. It's actually safe for you to disagree in your boardroom. But when somebody outside disagrees with you, what are they going to do? They will take you to court because they have something to lose. So you have, as a board, have to take this responsibility to investigate very seriously. Now, what is an unreasonable nomination, or what is an unreasonable decision by the board? Boards, as I've said, have been given what we call public power. You know, in the past, traditionally, the power that now trustees enjoy under the Act was enjoyed by, and in some countries remains the same, is actually a power that is exercised by the state. The master of high courts gets to decide these things. It's not trustees. It's a public power. It's power that actually should be decided by government. But what government has done is that has said, we are going to give this power to you, trustees. You are going to do this on our behalf. You are closer to the members. You are closer to the people. We are going to give it to you to decide. So it's a power that you must not take lightly. It's a power that you must then exercise it reasonably, rationally, and you have to take into account things that are relevant. You can't be emotional about making these decisions. If you were to do that as trustees, you would have discharged your responsibility. And it's very unlikely that any court would ever overturn your decisions.